Hello students, in this lecture number 7 on IPC we are going to discuss section number 19 and 20 of IPC. In section number 19 the meaning of judge is given, and in section number 20 the meaning of court of justice is given. Now let us discuss the bare language of section number 19. Section number 19 states about judge. So in IPC the meaning of the judge is given in a broad sense, because in this definition, judge word is not confined to a person who is officially designated as a judge, but it also extended to those persons who are empowered by the law to give a final judgment, or that person from the body of persons, which body of persons is empowered by law to give such a final judgment. Now let us discuss what is contained in section number 19. Judge. The words judge denotes not only every person who is officially designed as a judge, but also every person who is empowered by law to give in any legal proceeding, and that legal proceeding may be civil or criminal, a definitive judgment. Definitive judgment means final judgment, which will be binding on the parties to the case, or a judgment which, if not appealed against, would be definitive, or a judgment which, if confirmed by some other authority, would be definitive. Okay, this is one part of section number 19. Or, but also every person who is one of a body of persons, which body of persons is empowered by law to give such a judgment. It is very important. The person who is authorized to give a definitive judgment should be empowered by law to deliver the judgment. If he is not empowered by the law to give the judgment, then he cannot be regarded as a judge, which is described in section number 19 of IPC. Now let us take some examples when a person can be considered to be a judge and when a person cannot be considered to be a judge. First of all, a collector exercising jurisdiction in a suit under Act number 10 of 1859 is a judge. Okay, sometime the suits are filed before the collector, and if the collector is exercising jurisdiction in a suit, and what will be the final result in a suit? It will be a judgment which is to be delivered by the collector. At that time collector will be regarded as a judge, although collector is officially not known as a judge. So first category is a collector exercising jurisdiction in a suit under Act number 10 of 1859 is a judge. Number B, a magistrate exercising jurisdiction in respect of a charge. So in this case, magistrate is exercising jurisdiction in respect of a charge on which he has power. On that charge, he has power to sentence to fine or imprisonment. So what is this power to sentence to fine or imprisonment is will be given after giving the judgment. With or without appeal is a judge. So B, a magistrate exercising jurisdiction in respect of a charge on which he has power to sentence to fine or imprisonment with or without appeal is a judge. Number C, a member of a panchayat and which panchayat has a power under regulation number 7 of 1860 of the Madras Code to try and determine suits is a judge. So in this case, panchayat is a body of persons, and in body of person each member will be regarded as a judge because that panchayat is given the power to try and determine the suits, and after the determination a final judgment will be given. So see, a member of a panchayat which has a power under regulation number 7 of 1860 of the Madras Court to try and determine suits is also a judge. Number D, it is very important. D point is very important. A magistrate exercising jurisdiction in respect of a charge on which he has power only to commit for trial. It is very important. He will commit the person for trial to another court, but he will not decide the case finally. So, if he will not decide the case finally, then in this case, he cannot be regarded as a judge. I repeat, a magistrate exercising jurisdiction in respect of a charge on which he has power only to commit for trial to another court is not a judge. So this was section number 19. Now let us discuss section number 20 of IPC. Court of Justice, as the name suggests, Court of Justice donate when a judge or body of judges are acting judicially. If that judge or body of judges are not acting judicially, then they cannot be regarded as a court of justice. For example, if a judge or body of judges are acting administratively, not judicially, then that judge or body of judges cannot be considered to be the court of justice. But if they are acting judicially, then they will be regarded as court of justice at that time. Now let us discuss what is contained in section number 20. Court of Justice. The words court of justice denotes a judge who is empowered by law to act judicially alone, or a body of judges which is empowered by law to act judicially as a body when such judge or body of judges is acting judicially. Let's take the illustration. A panchayat acting under regulation number 7 of 1816 of a Madras code having the power to try and determine suits is a court of justice. But when the judges transact only administrative business, then they are not a court of justice. So this is something about section number 19 and 20. Thank you very much.